Today, the U.S. Supreme Court released its decision in a highly anticipated case where Idaho's law protecting unborn children was at question. Now, the court announced that it had declined to rule on the merits of the case, but instead sent the case back to the U.S. Court of Appeals in the Ninth Circuit for further consideration. So the question is the Supreme Court sidestepping the issue? What does this mean for unborn babies in the state of Idaho? Well, here to unpack this is John Birch. He's the Alliance Defending Freedom's Vice President of Appellate Advocacy and the Senior Counsel at ADF. ADF was instrumental in assisting Idaho Attorney General Raul Labrador in this case. John, welcome back to Washington Watch. Thanks for taking time to join us today.
Here.
So what exactly does the Idaho law say? First, let's start there.
The Idaho law protects life beginning at conception with an exception to save the life of the mother. That's always been clear. Everybody's understood what that's meant, and after Dobbs, it was supposed to go fully into effect. The federal government, in response to Dobbs, has taken a federal law, the Emergency Medical Treatment and Active Labor Act, known as EMTALA, and that's simply a law that requires hospitals that receive Medicaid to treat indigent patients who critically need care when they show up at the emergency room. And the administration took that and turned it into an abortion mandate. And then they sued the state of Idaho to try to guarantee that emergency rooms could be abortion enclaves, even in a pro-life state like Idaho. And so that's the case that came to the Supreme Court.
And the Biden administration argued that the Constitution's supremacy clause gave this federal provision the ability to trump what the state had done in this pro-life law, correct?
Exactly. That was their position, but there were a couple of problems with that. The supremacy clause only kicks in if there is a conflict between federal law and state law. And here there was no conflict because federal law and state law are both aiming to preserve life, not take it. In fact, there's nothing in the federal statute, EMTALA, that even says a word about abortion. To the contrary, it treats the unborn child as an additional patient that emergency room doctors have to care for. So Idaho's position all along has been no conflict, no supremacy clause.
And so that actually came out in the oral arguments, the Biden administration admitting some things that showed that this was not in conflict. Therefore, the court threw this back to the Ninth Circuit. Why didn't the court just deal with the merits of the case?
Well, that's a good question, and we'll never know for sure. But the way that the controlling opinion, three-justice concurrence written by Justice Barrett, joined by Chief Justice Roberts and Justice Kavanaugh, the way they explained it is that the case had morphed because of the federal government's admissions. And after the Biden administration admitted that abortions were not required in numerous circumstances, that essentially Idaho's law remains almost entirely intact. And they said that the injunction the lower courts had ordered would not stop Idaho from enforcing its law in the vast majority of circumstances. So what went from a really broad dispute about abortion enclaves and emergency rooms became a very narrow one, and those justices thought this needed some further deliberation by the Ninth Circuit before they made a final decision. And so we'll take those concessions. They're absolutely terrific for protecting life, not only in Idaho, but in pro-life states around the country. And we'll keep litigating back in the Ninth Circuit, and if we have to come back to the Supreme Court, we'll do that.
Well, it would suggest, by one of the comments from one of the more liberal justices, Justice Ketanji Brown Jackson, that she said this: while the court dawdles and the country waits, pregnant people experiencing emergency medical conditions remain in a precarious position. And she lamented that this was not the end of it. So she's suggesting, by the way, I think that's interesting, pregnant people. I think only women get pregnant, but that's another topic. So it would suggest that she sees that the federal government is on very thin ice in terms of trying to stop this law.
I think that's right. And Justice Alito wrote a dissent joined by Justice Thomas and Justice Gorsuch that really laid out Idaho's position and explained why Idaho was correct and that the Supreme Court could rule in favor of them right now just based on the simple statutory text. And the majority of the justices didn't think that was appropriate. They wanted to give this a little bit more process, but that does signal where the court is likely headed if this has to come back a second time, either because this case goes down to the Ninth Circuit and comes back up again, or because a very similar case out of the Fifth Circuit, which ruled against the Biden administration and in favor of Texas and some pro-life doctors that ADF represents, that there too, that the EMTALA rule was an invalid interpretation of the Federal Medicaid Act.
Well, when you look at the application of this EMTALA, the Emergency Medical Treatment and Labor Act, this shows that there's clearly those that want to, on the left, make abortion a federal issue. So this, I think, undermines the idea that a state can be pro-life and not be molested by the federal government. There is still federal intervention when it comes to the issue of life.
Absolutely. After the U.S. Supreme Court in Dobbs said definitively that now the people in every state would get to decide what their pro-life policies would be, then the Biden administration walks in, takes a statute that had nothing to do with abortion, that requires protection of the unborn child, and turns it into a federal abortion mandate. And so, unfortunately, that's one of many actions this administration has taken to basically force on states abortion rights that don't exist anywhere in the federal code. And until they get reined in and learn their lesson, I think they're going to keep doing it. And that's really a harm to democracy. It's a harm to the rule of law, and it's a harm to unborn children.
John, thanks so much for taking time to join us. Appreciate, once again, the great work that Alliance Defending Freedom does.
My pleasure. Thank you.